Hi again, everybody. This is Mark Mofsessian. I'm the director of the Mattone Center for Law and Religion at St. John's, and I'm back once again for another episode of Legal Spirits, which is our podcast series on cases and issues in law and religion. You can find past episodes archived on our website, which is lawandreligionforum.org, and also on Apple iTunes and Android and Spotify and other streaming platforms. If you like the content, please subscribe so that you can be notified as new episodes become available. Well, we've covered many law and religion cases on legal spirits over the past 60 or so episodes, but this episode breaks new ground for us because it's the first time that one of my St. John's colleagues has been a litigant in one of the cases that we'll discuss. The case is a recent challenge to a decision by the Cedar Grove School District in New Jersey to survey elementary, middle, and high school students with respect to sensitive demographic matters, including gender identity, race, and ethnicity. Now, one question on the survey that the district gave to high school students asked about students' religious affiliation. And why the school wanted to know about that is a little unclear. That's one thing I'll ask our guest to explain. The students' answers purportedly were anonymous. Now, the survey took place in 2021. Several parents of kids in the Cedar Grove School District objected to the surveys at the time, including today's guest, my colleague at St. John's Law, Professor Patricia Montana. The parents complained to the New Jersey Department of Education and also to the U.S. Department of Education. In late 2021, the New Jersey Commissioner of Education ruled that the surveys violated two state statutes, and as a result, the district was required to discard the surveys and any results from all the records. Now, the state statutes didn't expressly address religious affiliation, but a federal statute does. And the parents' federal complaints had gone unresolved until just last month. So that's 3 years after the parents filed their complaints when the US DOE issued its decision. DOE concluded that the high school survey, and particularly the question about religious affiliation, which I want to talk about today, violated a federal statute, the Protection of Pupil Rights Amendment, or PPRA, which requires a school district that wishes to survey students on certain subjects, including religion, to notify parents in advance and allow parents an opportunity to opt their children out of participation in the survey. So DOE ordered the school district to train its employees so that violations of the statute don't occur again, and also to provide documentation of the training, and also to notify parents of their rights under the PPRA. Now, in today's episode, we'll talk with Patricia about this case, how the case developed, the interactions she and other parents had with the school district, what the PPRA requires and why, and also implications for the future. Now, I should note that although the parents' complaint involved survey questions other than religion, we're going to focus mainly on the religious affiliation question today. So, Patricia, welcome to Legal Spirits.
Thank you so much, Mark, for inviting me on your podcast. This is a first for me, too. While I have spoken publicly many times, especially in my role as a parental rights advocate, this is my first podcast. And I do want to state just at the outset that even though I am a fellow law professor at St. John's, all of the activity that I did on this case was done in my capacity as a parent and not affiliated in any way with the law school.
Well, I'm glad this is your first podcast. I think you're going to enjoy it. I know I'm going to enjoy it. So Patricia, why don't you give us some background on the case? How did this case develop?
Sure. So to set some important context first, this all occurred in the cover of COVID. So during the 2020-2021 school year, the Cedar Grove School District was not offering full-time in-person learning, as was the case among most schools around the country. The students were splitting their time between in-home, virtual, and in-school, in-person learning, all while masked, of course. And I was very much against many of the district's COVID policies at the time, which I thought were detrimental to students, including my own kids, who, as you said, were students in the district. Therefore, I started to object to the school's policies, speaking out at Board of Ed meetings, organizing with other parents, and advocating for full-time in-person learning. I quickly developed a reputation in my community for being outspoken on these and other issues.
Okay, so thanks, Patricia. That's general background, but what about these surveys in particular?
So these surveys in particular, so it was during this time that the school district decided to secretly establish this Equity, Diversity, and Advisory Council called EDAC in our district. And that council's agenda included secretly surveying our children on some highly sensitive information, despite very clear and explicit laws that required schools to keep parents notified and give them an opportunity to opt out or at least inspect the surveys before they were given. And it was not until after the surveys were administered and distributed to our children that parents became aware of them. In other words, after the harm had already been done.
I see. So you didn't find out about the surveys until they had been administered. So how did you find out about the surveys, you and the other parents?
So I found out from my middle school boys shortly after they received them. They were all worked up and anxious to tell me about a questionnaire that kids got in their school emails that asked some really weird questions, weird being the term that they used when they arrived home. Students were confused. They didn't know what to make of the questions. So I immediately logged on to my kids' school emails. I reviewed them and was in total shock at what I saw. Soon after, I started receiving many phone calls from parents, including parents of third and fourth grade students, saying that they completed a similar survey in class. Now, remember, third and fourth graders are 8 and 9 years old.
Mm-hmm.
And my youngest child at the time was in elementary school, so was 9 years old. I immediately wrote to the school then asking for more information about who received these surveys and why, and I got no response. Then I advised the school that I believe they violated my children's privacy rights and told them I didn't consent. Still, I received no response. At some point, though, later that day or maybe the next, an email went out to parents with a community survey mentioning, and vaguely I might add, about how students got one on their own.
Okay, so we're going to talk about your children's privacy rights in just a second in the federal statute, but what did these surveys ask the students?
So the surveys were a little bit different, but all the student surveys solicited the students' race and ethnicity as well as their gender identity. The high school survey also asked for the students' religious affiliation and family demographic. And the middle school and high school surveys also solicited examples of different types of discrimination. And I know you're most interested in the religious questions. So the high school survey also asked, and I'll quote, can you provide examples of racial, gender-based, or religious discrimination you've experienced in the Cedar Grove School District? And so this question, you can get a sense from it just how leading the questions were, directing students to come up with specific examples. It's important to note that the middle school and high school students received the surveys via email during school. The third and fourth grade surveys were distributed in class, and students were instructed to complete the surveys as a class assignment. So the surveys were not voluntary, and indeed the state agreed with us on that very point, nor were they truly anonymous, because as the state said in its decision, any clarifying questions, particularly with respect to the elementary school ones, would have been asked in person of the teacher, negating the anonymity of the survey.
Yeah, I see. So as I listen to you talk about these surveys, especially the survey about religious affiliation, has the district ever explained why it wanted to know about students' religious affiliations? It seems kind of, well, the word you used was weird, right? I mean, why would this be asked? So I teach a class in comparative law and religion where we look at the laws of other countries. And German constitutional law has a concept of, quote, negative confessional freedom, close quote. And the idea is that just as the state can't stop you from expressing your religious beliefs, the state also cannot require you to reveal your religious beliefs. That's why it's called negative confessional freedom. And obviously, given German history, this is a really important concept in German history. But I think the same issue would come up here, that, the state can't require anybody, including students, to reveal what his or her religious beliefs are. And it's odd to me. I mean, I imagine the district's motives were benign here, but still it seems very strange.
No, so we never got an explanation as to why, and in particular with respect to the religious affiliation question. But I don't believe that the district's motives were benign. I think they acted likely in bad faith. And I want to start with the secretive nature of the surveys.
Yeah, mention that. You say you saying it's secretive. So how is it secretive that they did this?
So it was secretive in that the committee was established in secrecy without the knowledge of the community members. The individuals who were selected on the committee were kept secret, were kept confidential. even after parents complained, and hundreds of parents complained about the surveys.
Hundreds of parents. Wow, it's a lot.
Yes, hundreds of parents complained and signed on to letters explaining their grievances and their concerns over the surveys. So even after those complaints, and many of the parents, just so you know, were educators, so knew what you could and couldn't ask students. Many were lawyers, not just myself. And after they were advised that they violated the law, the district refused to listen. Instead, they doubled down. They published a summary of the results of the survey over our objections. And parents were never even given copies of the surveys. And so when you ask, why do I think it was in bad faith? Why didn't we get copies of the surveys after we asked for them and after our students were subjected to the surveys? And the only way we got to see those surveys was in response to OPRA requests, so an open public records request. And the only way we figured out who was on the EDAC, on the committee that created the surveys, was through OPRA records as well.
So I guess, look, I mean, the school district, I suppose the argument they'd make, we can talk about this as well. Look, we're trying to, increase diversity and inclusion, and maybe the students we need to get this information so we know the problems we're dealing with, and we're doing this all anonymously and so on. That you don't buy that.
I don't buy it. And certainly I should mention that was the purported reason for the survey. They claimed, and I'll quote, that the reason was to explore diversity and inclusion in the Cedar Grove public schools and seek to eliminate bias and enhance diversity in all our schools. But as I mentioned earlier, the surveys themselves were leading.
Right. They asked for any examples that you could give us. Yeah.
Correct. They intruded on students' privacy rights, and they created more harm. And in the case of our community, stoked more division than there was previously.
Yeah, I'll just make an observation. You can comment on this or not, Patricia. But to me, it's odd that the school district, didn't perceive that these questions might make students, including students from minority religions, feel awkward, and that they might cause awkward feelings and concerns for the parents too. I mean, it's completely understandable that kids would be reluctant to reveal their religions and to trust school officials with that information, even if the school officials say, we're good guys and, good people, and we're not going to cause trouble. We're not going to reveal this. I mean, even if the school district was acting in good faith, which I know you and the other parents doubt, it's just odd to me that the school district didn't see that they were wading into a very sensitive area where people could legitimately say they shouldn't be.
Yeah, it was astonishing to us parents. Of course, the questions were intrusive. That's why they are expressly protected under the federal statute. I think the school district knew they were, which is why they proceeded, as I said, in secrecy, asking those questions without our knowledge. And we know that students were uncomfortable. Many students were upset by the survey. They came home upset. They reported back to parents the discomfort and confusion they felt. And for our elementary school children, some of them came home crying and asking very serious questions about why there are differences between them and other children in their classes, questions that parents were unprepared to answer.
Yeah, although they weren't asked about religion.
Correct.
Right?
That is correct.
But I assume even the high school students being asked about religion would have, they wouldn't maybe cry about it, but they would have similar reactions too. So how did the district react when you and parents complained about this?
So from the very beginning, they implied that anyone who questioned the surveys were opposed to diversity and inclusion, and by extension, racist and homophobic. But as we stated in our legal papers, as parents, we've always advocated for the inclusion of all Cedar Grove children and community members in all aspects of the school district. And we support the goals of the New Jersey statutes, directives that require schools to develop plans to identify and correct all discriminatory and inequitable educational policies. Those goals, and we underscored this in our legal papers, can and should be achieved within the parameters of state and federal law. And not a single law or regulation requires surveying children to determine a school district's needs for achieving equity and diversity in educational programs. In fact, the New Jersey regulations do not even recommend surveying children for this purpose. Rather, their regulations envision that school districts determine the district's needs through an exhaustive list of other measures, none of which the school district exercised. And so, because they refused to listen to us and adhere to the laws, we were forced to take legal action.
Yeah. So, okay, I know that you and the other parents complained about violations of New Jersey law. I mentioned that at the top of the podcast. But the New Jersey law doesn't talk about religion specifically. So, I want to focus on your complaints about the violation of this PPRA, the federal statute, which I think comes from the 70s. And so, what does the PPRA say?
So the PPRA requires written consents from parents of students before they're required to participate in a survey that's funded either in whole or in part by a program of the U.S. Department of Education, and that concerns certain areas, which the PPRA refers to as, quote, protected information. And these areas include, among other things, information about political affiliations or belief of the student or the student's parent, mental or psychological problems of the student or the student's family, and importantly, religious practices, affiliations, or beliefs of the student or student's parent, or income, other than that, which might be required for participation in some program receiving financial assistance.
Yeah, well, these are all very sensitive things. And as I understand the statute, there's a difference between federally funded programs and programs that are not funded by the federal government. And I guess the program that we're talking about here wasn't funded. So there's some difference between the two?
Yes, so the EDAC, the committee that created the surveys, was not federally funded. So if the surveys were developed or funded as part of a program administered by the Department of Education, the PPRA requires that school districts obtain prior written consent. For unfunded programs, as was the case here, the school district must notify parents in advance of its administration of the surveys, give them an opportunity to inspect, and provide them an opportunity to opt out. So there's a slight difference, but in both of those cases, parental notification and knowledge are paramount.
So what was the motivation for the PPRA? Do you know, Patricia? I mean, why was Congress concerned about these surveys? It seems like it's a kind of student and parental rights provision.
Yeah, to be honest, I don't know a lot about the history and motivation for the PPRA.
Well, it does seem very obscure. I mean, I'm going to ask you later. I mean, how did you? Well, we'll come to that.
Yes.
I mean, how did you even find out about this? But okay, so tell us about a little bit about.
Yeah,
what
so
was
there is little to no case law on the subject nor scholarly work. So what I do know stems mainly from the U.S. Department of Education's website, and as the name suggests, it was intended to protect student privacy rights and ensure that parents had full knowledge of how and on what topics their children would be surveyed. So for the parents of Cedar Grove, the statute was extremely crucial. We're able to point to a federal law that agreed with the principle that parents had a right to know what's being taught in the classroom.
Yeah, and so I mean, it is kind of remarkable that the district didn't know about this, or if they did know about it, they would ignore it. I mean, as you're talking, I'm wondering, did maybe they not know about this? But that can't be the case. And if it is the case, it's kind of dereliction of duty.
Correct.
Yeah.
Correct. It's so straightforward. The statute actually has religious affiliation as protected information, and the question on the high school survey asked for students' religious affiliation.
Right, and so you had to go to the PPR complaint procedure, I guess, because the school district wasn't listening to you.
Correct. Yeah, we were forced to take advantage of the PPRA complaint procedure. The school district refused our simple demands. Parents wanted simply for them to discard the survey and its results, tell us who was on the EDAC committee, and apologize, take accountability for infringing on our children's privacy rights. And we also did want to send a message to the school district that we're paying attention to what they were doing, to the extent that there were other things that they were doing in secret.
Yeah, and the school district is presumably being advised by lawyers, and a lawyer could just look at this and kind of figure out this is a mistake, which is what you did, right? So I wanted to ask you this. How did you even learn about this obscure federal law? I mean, I never heard of this law.
Yeah, so I learned about the statute after first researching the school district's published policies. And by law, they're required to adopt and publish their district policies on a website. So I went to the website and I came across one dealing with surveys. And because of my background as a lawyer, I understood that the citations at the end of them were citations to both state and federal statutes. And so from there, I looked up the statutes themselves, and it only took moments to understand that they violated the express terms of the PPRA. We call this in law school, right, in a first year course, an undisputed issue.
An undisputed. No. This is the whole thing is just so strange to me that they would ask the questions, and strange that they didn't immediately back down when the statute. It's just opaque. So anyway, it took some time, though. We have to be fair to them. It did take some time for the DOE to rule on this, and they ruled last month. So what did the U.S. DOE say about all this?
So they first found that the PPRA applies to surveys whether or not they are anonymous. So the law prohibits a school district from requiring that a student submit to a survey that would reveal information on a topic like religious affiliation, but it doesn't need to be information that is personally identifiable for the PPRA to apply.
Right, and that makes sense to me because even if it is anonymous, and again, I know what you said before, it was not clear that these were really anonymous surveys. You would think that even if you're doing it anonymously, if you are being forced to reveal your religious convictions, that could make you feel very uncomfortable, even if it's totally anonymous. So you can see
Correct.
why that'd be the case.
Correct. Yes. So after making that point, the DOE found that the high school survey questions related to income and religious affiliation were protected information under the PPRA.
Again, seems very straightforward
Yes.
given what you said the statute says.
Yes, and thus required prior notification, inspection, and opt-out opportunities. Now, as you recall, the elementary and middle school surveys did not ask questions relating to religious affiliation or income. Nonetheless, we had argued that the gender identity question implicated the PPRA as well, the category called sex behavior and attitudes. And the New Jersey Commissioner of Education agreed with that argument, yet the U.S. Department of Education decided not to answer that question. And its rationale was that it had not yet issued formal guidance or regulations that would clarify the applicability of the PPRA to such questions. And even if it had found a violation because of the gender identity question, the Department of Education thought that the corrective measures would have been the same for their finding with respect to the high school survey. And so they didn't reach that. They didn't reach that question.
Yeah, okay, I understand that. And anyway, I wanted to focus on the religion question here. So, but I guess there's a footnote also you wanted to talk about in the DOE decision?
Yeah, so there's this interesting footnote where the U.S. Department of Education points out the New Jersey's ruling and says that as a result of it, similar questions on gender identity, quote, cannot be asked on future surveys administered to students without prior written parental consent. This provides protection at least equivalent to, if not greater than, PPRA if it were to apply. So in our view, there's some agreement with the New Jersey decision on that point.
So I don't want to get into the New Jersey decision too much, only because it doesn't relate to religion, which is our principal interest here. But I do want to make the point that the New Jersey DOE acted very quickly, apparently within the matter of months of your complaint, but the U.S. Department of Education took 3 years. So that's a big difference. Patricia, do you have any sense of what occasioned the delay? Why did the U.S. DOE take so long?
Yes, so there was no good explanation for the delay, other than that they were under no obligation to act fast, legal obligation, or even to act within a specific time period. So I should mention here that after about a year or so of no response from the United States Department of Education, American First Legal took on our case pro bono, and they ended up filing a complaint in federal court on our behalf. And in the Department of Education's motion to dismiss, they argue that there's no statutory or regulatory provision requiring the department to complete its investigation into a PPR complaint under a fixed timeline.
I see. So they weren't saying that there was no violation of the statute. They were just saying we don't have any obligation to move right away. So
Yeah.
you have to just wait.
Correct. And they argue that Congress explicitly gave the Department of Education the authority to devise the system for investigating, processing, and adjudicating violations, as well as the discretion to decide when enforcement action is appropriate.
So there was never any point where the DOE suggested you don't have a case. It was just that we need to take our time and whatever.
So before AFL got involved, I would periodically check in with the U.S. Department of Education person assigned to our complaints, and he simply sat on them, did nothing. I suspect that they were not acted on because the current Department of Education does not wish to prioritize transparency and parental rights.
Yeah, because I don't understand why it seems like such a clear case of this statute. I mean, it's true, no one's heard of this statute, but the US DOE has heard of this statute, and it looks pretty clear that this was a violation. So, okay, Patricia, well, it sounds like you and the other parents won a great victory here by your lights, and so that's a success. And what's your plan going forward?
So our plan going forward is to continue to monitor our school district and serve as a model for other school districts throughout the nation. There's no better reason to unite, speak out, and battle in the courts than to advocate for the rights of your children. I'm thankful to the many parents who joined me in the fight, to our former colleague and my dear friend Elise Pepper, who worked tirelessly and together with me on all these legal matters, offering her research and writing expertise and wisdom. I'm thankful to American First Legal, who pursued the matter for us vigorously in the federal courts. And then, of course, to you, Mark, for giving me this platform to describe this incredible 3-year long journey.
Well, thank you, Patricia, for joining us. I mean, it's been a great episode. I guess I have one last question is, why don't you write this up? This sounds like it could be a good law review article.
I might, especially now that it's come to a conclusion.
Right. No, I think it'd be really interesting to talk about this statute. And I think many more parents would be interested in learning about this statute because I mean, in some sense, it was just serendipitous that you're one of the parents and you're a lawyer and you recognize that there's something here, because I think most people simply would go past it. So, well, anyway, thank you again, Patricia, Professor Montana. It's been great to have you as our guest on Legal Spirits. That's going to wrap it up for this episode. You can find past episodes archived on our website, lawandreligionforum.org, also on streaming platforms like Apple iTunes and Android and Spotify. I encourage you, please, to subscribe if you like our content so that you can be notified as new episodes become available. But that's it for this episode. See you next time.